Ms. Bourgeois Cooper, one of the things that stood out to me in your pre-sentence report, well, a couple of things. One, your criminal history is ridiculous. It's when I start having to turn page after page after page, that's a problem. And your version of this about I didn't really know what was going on, and I just went with somebody at the store, and I didn't know what county what I was in. You didn't know what county you were in because y'all were going from county to county to county, and still you're not going to help yourself by saying anything right now, okay? Because Ms. Shear was just here and has you on video at other stores doing the same things. So I don't dispute what she said under oath at all. I think Mr. Lane did an amazing job for you, and you are very lucky because he got you the cap of 12 months because you deserve a lot more, in my opinion. At this time, I'm going to find that you entered your plea of guilty freely and voluntarily. And in cause number 24 DCCR 1296, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. And all I can tell you, Ms. Bourgeois Cooper, is that I hope you learn your lesson while you're in state jail, and stop all of the stealing, because each time you do it, this is only going to get worse. It's going to get enhanced. You're going to get more time. At this point, you now have, I think, 2 felony convictions, and that's going to start adding up, and you're going to end up with a lot more time and going to TDC instead of state jail. Do you understand?
Officer with HEB, have you become familiar with the defendant, Alexis Bourgeois Cooper?
Yes.
Please explain briefly to the court how you have come to be familiar with her.
She originally came on our radar back in February of 24 when she started stealing from our stores in Montgomery County. And then she was pulled over shortly after stealing at a Conroe store. And that's how we were able to ID her.
And you understand that she's already pled guilty today to a state jail felony level theft for $3,547 worth of cosmetics and makeup from a HEB store in Port Arthur. You understand that, correct?
That's correct.
And she committed that offense along with co-defendants Katira Green and Monique Wynn. Please briefly tell the court your familiarization with Katira Green and Monique Wynn.
Both of those parties are part of an organized retail crime and a spree group that we've been following about at the same time. And they have in Houston area, Katarina Green has for stealing from our stores about $56,000 worth of cosmetics, and Monique.
Your Honor, I just object to any co-defendants' restitution amounts or what they've pled guilty to or found guilty of.
That's overruled. Go ahead.
And then Monique Wynn was about $42,000, and they're part of a ring that was hitting our area for a short period of time.
During the period of February the 24th through April the 24th, how many actual thefts did your investigation link to the defendant, Ms. Cooper?
10 events.
For a total loss of how much?
$8,956.50.
Now, for the entire ring, what approximate dollar amount would you put on? Well, let's break it down. What about for Wynn, defendant Wynn? How much would you attribute to her?
About $42,800.
And for the defendant Green, how much would you attribute to her?
$56,000.
Is it fair to say, in your opinion, that this group has been operating as an organized retail theft ring?
Yes.
And have you, in your 5 years of experience in loss prevention, have you, how would you rank this this endeavor?
This is about the second highest ring we've had in HEB.
And you prepared a report?
Yes.
Okay, and you reviewed that report
That is
prior to testifying here today?
Yes.
All right, I'll pass the instruction.
Thank
No
you.
questions, Your Honor.
Thank you, ma'am. You can have a seat.
Judge, just if I may, I don't know what I was thinking today that I agreed to a cap of 12 months. I certainly see how the court would be inclined to give this defendant more than 12 months, Judge. Well, actually, I do know what I was thinking. If you look at her criminal history, she actually has not been to prison before. She's got a number of misdemeanor thefts, at least theft arrests.
Not enough felonies that have actually been convicted and followed through that would get enhanced either. So, I mean, I could see my initial thought was the same. I wasn't quite sure where this came from. But I can see that it's not really enhanceable at this point based on any other felonies. So, Mr. Lane?
Well, Your Honor, obviously, we're asking the court to follow the agreement that was entered. The court does have the ability to sentence her to 12 months in the state jail. She did have a 1244 in Harris County that she did 10 months in the state, in the county jail. She does have a pending case out of Hidalgo County. What had happened back in 2019 and 2021 is her father and her grandmother died. And then she did get involved with these thefts. That was a major setback for her. She does have custody of 3 children. She is a phlebotomist and has some other skills that she can earn money with. So we're asking that you follow it. She has a family law hearing that's the 24th of this month. We would ask you to sentence her to 10 months in the state jail.
Mr.
Oh,
Coleman?
we'd ask for the entire 12 months, Judge. Excuse me. I think she's benefiting from Mr. Lane.
Is that who is it? What is she?
She's benefiting from Mr. Lane's negotiation with me in working me down to a cap of 12. I'd ask for the entire 12, Judge.
Yeah.
Okay.
Sorry. Yeah, I didn't realize the other issue as well.
Your Honor, before we start, I just wanted, we're actually here because I filed a writ because he had been in jail for more than 90 days. Since that time, I've got an offer, but I still would like to address I mean, he's taking a plea and I just want to address his bond. Or if we could waive a PSI possibly, I don't know. He has no record that I'm aware of.
Can't wait PSI because it's not a state jail, but she can get.
I'll
Okay.
get to that. We'll talk about
Okay.
that. All right, so are you Gregory Barnum? And Mr. Parker, will your client waive the formal reading of the
Hey,
indictment?
well, Your Honor.
Getting. Mr. Barnum, in cause number 26, DCCR 1472, you're charged with a third-degree felony offense of injury to an elderly individual from May 5th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? You look confused when you're saying yes.
Well, I signed, am I getting good? Yes, I did.
Did y'all go over them?
Yes,
Okay. Do you understand the documents that you signed?
yes,
And do you understand that if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreement that you've reached is for an 8-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Barnum is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for punishment so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Mr. Smith, what is the state's position based on that plea agreement with regard to a reduction in bond?
No objection.
So, Mr. Barnum, obviously, part of your plea agreement is going to be that you have no contact or communication with Gregory Barnum Senior. What I'm going to do today, based on the nature of this plea, is reduce your bond in your case to $1,000. I'm going to make that a personal bond. That means you're just going to get out and not have to pay any money. Couple of things are very important about that. If you don't show up on your court date for sentencing, then they can come after you, obviously, for the $1,000. But more importantly than that, if you don't come back or don't show up, then I don't have to accept this plea agreement. Things could be worse. Another thing is that the first thing you will be required to do when you get out of jail is go straight to the probation department. You'll get some information today about where that is and what you need to do so that they can get that report done. Obviously, if you don't do that, you also run the risk of me not accepting the plea agreement. And then finally, if you violate that condition of your bond, I am making it a condition of that bond that you don't have any contact or communication that's directly or indirectly in any way with Mr. Barnum Senior. If you do, again, you run the risk of me not accepting the plea agreement.
No problem.
Okay, perfect. We'll see you back at sentencing.
Are we gonna just reset that other one?
We have to,
That'd be perfect.
Yeah, we've got, what about?
I didn't want you to do that.
Yeah.
The other one's been recessed.
Later time.
She asked me, but I don't think that he wasn't included in that conversation. And so there's an issue, an appointment that you.
The other one's been reset. He picked Marielle.
Marable.
It's already been reset.
Okay.
He picked up a new case, so the court reset it.
Okay, we're going to reset Luciano Sevilla. Yes, ma'am.
Thank you, Judge.
Yes, sir. Mr. Eckhart, you have Mark Marceau.
I do, Judge.
Marceau. Good morning. Morning, Ms. Finch. Good morning. Wait. She gonna get him back there.
He's pretty much deaf and
Doing great.
barely sees that one eye, so he
Oh.
probably cannot hear.
Gotcha.
They're calling his name.
Should take that thing off that page.
Uh-huh. Good morning. Are you Mark Marceau?
No.
And Mr. Marceau is charged in cause numbers 26 DCCR 0396 and 0397 with sexual assault of a child, and in 26 0398 with continuous sexual abuse of a young child. And what is the announcement?
Judge, I think where we're at right now is, one thing I do believe we're still waiting on is the CPS records. I haven't received a notification. I checked Ms. French this morning. I don't think she has either.
Have they been requested?
Yes,
Yeah.
but there's an order. I think we're just waiting on the court to receive it.
I was just looking at, it must be in one of the other cases because I don't see it in 0396.
I believe it would have been in the last cause number is what Ms. French filed the order in.
Gotcha. Double check when that was done. And
That would have been roughly 50, 60 days. To say.
I signed that order May 22nd. Ms. French, what I'll do is I'm going to reset the case so we can get those. If you can contact Stephanie over there. Usually she's pretty good when we're waiting on something with someone in custody about getting those records to us a little quicker. All right, we'll just do, what I'm going to do actually is a 45-day reset, because by the time we get those, you have an opportunity to review them. Hopefully that'll give everybody plenty of time. We can get the announcement at that date.
Yes, ma'am.
Okay,
Thank you,
thanks.
Judge.
I think I forgot. Did we reset Ronald Spites for Mr. Gertz?
Yes.
Okay, it's not on my.
I'm sorry.
Mr. Macon, you have Cyprian Avedonte.
Yeah, Miss French and I have been talking.
Hang on, hold on. Let's get him out. Okay. I'm trying. Yeah. I feel like we've done this before, though.
Morning.
Good morning. And tell me how to pronounce your last name again, please.
Avadante.
And Mr. Avedonte, in cause number 23, DCCR 1466, you're charged with unlawful interception or use of electronic communication. And what is the announcement?
Your Honor, Miss French and I have been talking and she needs a little more time to, I think, get back with me and I'll evaluate that. I asked for a 30-day reset.
All right, so and I understand that you might have just gotten this recently, but you were hired back in February.
Yes.
So it's time definitely to get something moving on the case. This will be the final reset. You guys get together, visit, and if there's an offer that's acceptable, great. If not, it's time to get this thing set for trial. It's very old. All right, you can go back with bailiff. This will be the last reset for an announcement.
Thank you.
Thank you, Judge. If you'll make that notation, please. Thank you, ma'am. And that right to appeal on Sevilla that we're not going to do today. Do you want me to just send it back to you or just leave it here? No, it said it's in use.
Thank you.
Okay. Perfect. Thank you, ma'am. Mr. Burbank, are you ready to announce on Samuel Harmon? Morning.
Good morning, Judge. I'm gonna have to put Mr. Burbank on the stand later this week. It's a good day for me.
Oh, any day. Any day.
Statute of limitation.
Well, there is that.
There you go.
Good morning, sir. Are you Scott Harmon? I'm sorry, Samuel Harmon. And Mr. Harmon has two cases, cause numbers 25 DCCR 1019 and 26 DCCR 0385 set for trial to begin with jury selection next Monday. And what is the announcement?
Yeah, I intend on going to announce not ready. I was just hired. I know that it's been, you had a previous attorney. When I got hired, I realized that there were mental health records from the jail, and also when he was in the free world and some videos I haven't. So, I mean, I guess if you get in a jam, but
No, well, let me ask you this. If I reset it off the trial docket or do you anticipate it still going to trial? You still need that information? Or do you want me to put it maybe on a status and then we see since you just got hired?
I'm sorry, Judge. I would ask for a status because depending on what the records and mental health evaluations are, then I know that Mr. Nichols is in trial this week, and last week I was out of pocket. So yeah, I would
Okay.
ask for a status.
So what I'm going to do is reset the two cases off the trial docket onto a status in about 30 days, give you some time to kind of get caught up, get that information to Mr. Nichols, and we'll see where we go from there. Mr. Nichols?
That should be fine.
Good. Okay, perfect. All right, go back with the bailiff, sir. Yes, sir. You also got Relacia Mouton.
And we signed up.
Oh, I see.
went through.
Okay.
Are you ready for her?
Yes.
Okay, I just need her just signatures.
Yeah, go ahead. And how many are coming through?
I have 3 and 2 of them are being dismissed.
Okay.
All paperwork's been sent to Thursday.
Right here.
Um,
Yeah, right.
Thank you, Mel. Good morning, ma'am. Are you Relacia Mouton?
That's right.
And Mr. Burbank, will your client waive the formal reading of the indictments in each of the cases?
Sure will, Your Honor.
Before we go forward, I'm also going to take judicial notice in all of the court's files on Ms. Mouton. Ms. Mouton was examined for competency to stand trial by Dr. Capon. I received that report dated July 21st of 2026. The finding after that examination was that Ms. Mouton was competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor, I've received the report. I would say for the record that through my representation of Ms. Mouton, she has answered all my questions. She understands the proceedings. So I feel confident to move on with this plea agreement.
Thank you. Anything else from the state?
From the state.
Then based on that information from Mr. Burbank, as well as the report, I am going to find that Ms. Mouton is currently competent to stand trial. We going on count
We can go and count.
one only, at least in the first one?
And all of them.
All of them, okay. Get that pulled
There
up.
are 2 second degrees and 1 state jail.
Okay. Ms. Mouton, in cause number 25, DCCR 0907, the state has elected to proceed on count 1 only. It alleges that you committed the second-degree felony offense of assault on a peace officer, and that was from May 2nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
Sorry, I've got to get it pulled up the right way in each of the cases to make those notations. Now, in cause number 25, DCCR 1466, the state has also elected to proceed on count 1 only. It alleges again that you committed the second-degree felony offense of assault on a peace officer from August 17th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then finally, in cause number 25 DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, states one in each case, Your Honor.
It's admitted in each case. All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Again, make that finding that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 25 DCCR 0907 find sufficient evidence to find you guilty. And at this time, finds you guilty of the second-degree felony offense of assault on a peace officer. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 1466, also find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in 25 1467, find sufficient evidence to find you guilty, and at this time finds you guilty of possession of a controlled substance, a state jail felony. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will run concurrently, which means together at the same time. I'm also going to sign dismissals as part of this agreement, and cause numbers 25 DCCR 1468 and 26 DCCR 0120. I've handed you the trial court certifications in each of your cases that shows that these were agreements and I did follow them, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, ma'am. Thank you.
I be excused, Judge.
Yes, sir. Thank you, Mr. Burbank. Oh, no. The one she's resetting, we don't even need that long, just a week or 2. Yeah. I did, but we didn't talk to Mr. Parker about that. And he actually has an appointment that he cannot miss in a little bit. So that's okay. Tell her not to worry. We reset it.
Oh, okay.
We had to. Mr. Parker had to leave.
Okay, I'm letting.
Yeah, I didn't realize that. We should have included him in those discussions and did not. And I know she has some witnesses, so probably the sooner the better for her to let them know what happened. Thank you very much.
Let you know. Hey, Tom.
Have you already told her? Mr. Rojas, you've got Sarah Jordan.
Can we hold that one?
Sure. Okay, and then you've got Jalen Hendricks. It's a bond hearing.
We need him.
Yes, please, sir.
No.
Good morning. How are you?
Good, how are you?
Good.
Yeah.
Charlotte, I've got some holy power that I have to be talking about. Oh.
Up front.
I'm printing an administrative hearing just so I can read it better on this one. Good morning. Are you Jalen Hendricks?
Good morning as well.
And this is cause numbers 23 DCCR 2323. In that case, Mr. Hendricks is on probation for evading arrest or detention with the use of a vehicle. A first amended motion to revoke probation has been filed in that case. And then we also have 25 DCCR 0574. Mr. Hendricks is also on probation in that case for evading arrest or detention with the use of a vehicle. And there is a first amended motion to revoke community supervision in that case as well. Mr. Rojas has filed motions asking that bonds are set in both of those cases. And Mr. Rojas, do you intend to call your client?
I do, Your Honor.
Mr. Hendricks, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed. Go ahead.
You're Jalen Hendricks, right?
Yes, sir.
Jalen, where were you born?
Jefferson County.
Have you lived in Jefferson County your whole life?
Moved around from group home to group home.
When was that? Is that because you were in CPS care?
Yes, sir.
Have you ever lived outside of Jefferson County?
Yes, sir.
Okay, where was that at?
Houston, Dallas, Power, Texas. I came back to Beaumont at 17.
Speak up, please.
Houston, Tyler, Texas, Dallas. Then I came back to Beaumont at 17.
Thank you.
And all those other places that you lived, that was because you were moved around through CPS care, is that right?
Yes, sir.
Your only family is here locally in Jefferson County, is that right?
Yes, sir.
And that's your grandmother?
Yes, sir.
You don't have any other family, do you?
No, sir.
I think you told me you have a fiance though?
Yes, sir.
Okay, what is her name?
Jasmine Briscoe.
Chadlin Briscoe. Do you own any property that you could sell? A house, a car, land, a boat, trailer, anything like that?
No, sir.
Okay. Do you have a bank account?
Joint bank account.
A joint bank account with who?
My grandma.
Okay, and do you know how much money, about how much money is in that bank account?
1,000.
About $1,000. And do you put money in that account? Does your grandmother put money in the account?
You both do.
You both do. And where did you get your money from that goes into that account?
Social Security.
And is your grandmother working right now?
No, sir.
Okay, where does she get her money from?
Social Security.
So, you're asking the judge to set a bond this morning. How long have you been in jail right now?
Since August 5th.
And you're on probation for 2 felonies. And before you got placed on probation, you were sitting that time out in jail, weren't you? You were waiting in jail to get probation.
Yes, sir.
And so is it due to the fact that you think you may have $1,000 in the bank? And how much do you get a month for your Social Security?
About $200.
$1,200?
Yes, sir.
Okay. Is it realistically, how much money do you think you and your grandmother and your fiance could come up with in order to make a bond?
2 or 3.
2 or 3 what?
Uh,
About $2,000 or $3,000? Okay.
And so are you asking the court to set your bond somewhere in the neighborhood of $20,000?
If she allows me.
Okay. Now, do you have the $2,000 or $3,000 with you right, or do you guys have that right now, or do you have to wait a little bit more time to come up to save that money?
I have to save a little bit.
Okay, so even if she were to set the bond at $20,000, you wouldn't be able to get out today, but hopefully in maybe a few weeks, your grandmas would be able to have that money.
Yes, sir.
Pass witness.
No questions.
All right, thank you. Any other witnesses?
No, Your Honor.
Mr. Smith, what is the state's position?
Judge, he's not entitled to a bond because these are both straight probations. These were not my cases. These were Mr. Coleman's that transferred to me after he left the court. Spoke with his probation officer, and she is here if you have questions for her, Judge, but it seems like he does report regularly, and I think he tries to pay fees as he can, but everything else he just doesn't. He got kicked out of immoral recognition therapy twice.
What's the status of the new assault? We're talking about this.
I think it's filed. They're just carrying along with this case.
I mean, he's talking about this female, like they're together, but there's a
I'm
bond
sure there's gonna be a
condition that
bond
he have
condition.
no condition, that no contact with her, because that's an allegation in this motion.
If I, does Ms. Briscoe, does she live with her grandmother, or does she have her own house?
She got her own house.
Okay, now you understand that if you were to be released on bond, that one of the conditions, probably in this case, but for sure in the misdemeanor case, would be that you don't have any contact.
That's fine.
And you're telling the judge you want to stay away from her.
Yes, sir.
Can you double check? Let me hold this for a second, what the status of that is down the hall. So, have a better idea. Just have a seat over there for a second, or wherever the bailiff wants you. I'm gonna recall your cases in just a minute.
Yes, ma'am.
That's just Larzo.
Just can we hold that one also?
Sure. What about Trayvon?
I'm ready on
Trayvon
it.
Patterson?
Ready on that one. That's gonna give at least one case.
Where's the one?
Good morning. Are you Trayvon Patterson?
Yes, ma'am.
Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr. Patterson, in cause number 26 DCCR 0521, you're charged with the third-degree felony offense of obstruction or retaliation from March 4th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you
Yes.
with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Patterson's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. And that'll just give me more information about you and your case, and we'll come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond reduction based on that plea agreement?
Judge, she has no other criminal history, and Ms. Mofino made a fairly lower range offer, so I think there's no reason not to.
So, Mr. Patterson, what I'm going to do based on the nature of that agreement is reduce your bond today to $1,000. I'm going to make that a personal bond. That means you're not going to have to pay any money. You're just going to get released from jail, but there's several very important things about that. So first thing is that as soon as you're released, you go straight to the probation department. You're going to get some documentation today before you leave that tells you where to go, but you've got to go get that process started so that they can do that report for me.
Yes, ma'am.
If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse. You understand? Also, if you're arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. You understand?
Yes.
All right, we'll see you back at sentencing. Let's see, you've got a sentencing, Mr. Rojas, on Jamie's story. Good morning. Sorry about that. We should have talked to Mr. Parker about moving that time. He had something. he had to get. Thank you. Didn't even think about running that by him. Realize. Right, are you Jamie Story?
Yes, ma'am.
And Ms. Story is currently on probation and cause number 23 DCCR 1546 for well, it's a state jail felony offense of theft of property, but it was enhanced back at the plea, I believe, to a second degree felony offense. There was a motion to adjudicate file. We were here. Ms. Story entered pleas of true to counts 1 through 7. I've received the updated report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections to the report?
No, Your Honor.
Only addition I would have is new deference to Ms. Lopez's comments.
Good morning, Ms. Lopez, and I've gotten your updated report. Is there anything that you would like to add to that?
No, ma'am, not at this time.
Okay, thank you. Mr. Rojas, you may proceed.
Yeah, Judge, Ms. Story's here this morning. She realized that she was already given 1 second chance on probation and she was sent to ISF. Completed that, was released. She was depending on her stepfather as a support system in her ride. Her stepfather died. She passed away, didn't have any transportation. She lived, I think, in Liberty at that time. She didn't have transportation, missed the first appointment, and then, like so many other people do, she got scared and started thinking she was going to be in trouble for not reporting, and it just snowballed from there. She stopped reporting. Again, her stepfather has passed away. He was her only support system. She realizes that probation is probably not going to be an option for her. We're asking the court to consider those circumstances and sentence her somewhere in the lower end of the range, possibly 3 years. I think Ms. Story would like to say something at the appropriate time.
I just want to apologize for, disrespecting you by not abiding by your rules.
Ms. Malfino?
Judge, I certainly appreciate that statement to the court, and especially no disrespect to you, Your Honor, but to Ms. Lopez, who has basically been chasing her around for years. I don't think it's fair for me to stand up here and argue for a lot of pen time. Honestly, the offer in the very beginning was a year state jail, which she turned down in order to try to get an opportunity at probation, which you gave her. And then obviously she has done absolutely nothing. So I will defer to whatever punishment you think is appropriate.
Ms. Story, you getting this probation in the first place. I'm looking back at the original pre-sentence report. This case was your 6th felony. and you got an opportunity at probation. Then you got opportunities while you were on probation. So it really is kind of a slap in the face to myself, Ms. Lopez, and everyone who tried to help you. I understand, needing a support system, but also you're how old at this time? Almost 50 or 46? 45, sorry. I was looking back at the old pre-sentence report. Anyway, it's just at some point you've got to rely on yourself to do better for yourself. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to revoke your probation, and at this time revoke your probation. Reassess your punishment to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I think we already went over that before when you were initially sentenced about you not being eligible to possess a firearm or ammunition. If you have any other questions about that, you've got that document to read. Also, you can ask Mr. Rojas. All right, Gillette, ma'am, you can go back with the bailiff. Did you get some information on Jalen Hendricks, Mr. Nichols? Well, who was looking, Mr. Smith?
No, not Hendricks. I was looking at something. I did look at Mr. Hendricks.
Okay, Mr. Hendricks, come back up, please. Hold on. Thanks. All right, we're back on with Jalen Hendricks. And what did you find out about that? I'm sorry.
The case is pending. It's in Judge Wood's court, and his next setting is a jail docket in there, September 24th.
All right, so any other evidence or argument with regard to setting bonds in these cases?
No, Judge, just to point out that I think these are his only felonies that he's ever had. He's got limited misdemeanor history, but I think these are his only felonies. So,
Mr. Smith, anything else?
No, Judge.
So, Mr. Hendricks, the problem I have is, well, a couple things, but first of all, it looks like you were placed on probation December of 2025 for 2 evading arrest. So you had one from back in 23, while you're on bond, you get another one, and you get this opportunity at probation. And then we've got a new offense, and we've got the fact that you just cannot seem to follow through with at least this MRT class and some other things on your probations.
I guess a couple other things, Judge. Probation brought to my attention the fact that the address they have for him is actually the apartment where the victim does live. So he was living with her at the time. There's also an emergency magistrate protective order that's good for at least 90 days. It prevents him from going around her for 90 days on top of the bond conditions that you have set. So he did it, I believe, say that he was living with his grandmother, that he was living with her until he went to jail. Living with the victim, not the grandmother.
Oh.
Mhm.
Back and forth. Grandma, stand with her.
After you were arrested for the assault on her. So after you were arrested for the assault on her, were you still going back and forth after that?
No,
Okay. I'm just checking what those original bonds was then. Okay. What's the address? Her address.
on 105 Trinity Groves.
Is that the address you have?
7110 Highway 105. 7110.
That's an apartment complex.
That's
Yeah.
where the complaining witness in the 7110.
Highway 105, apartment 725.
That Beaumont?
Yes.
What's her name again?
Jasmine Briscoe.
Jasmine?
Jasmine.
Jaslyn. How do we spell that?
JAZZY.
Briscoe?
Yes, ma'am.
Do y'all have any children together? What?
One
Who takes care of that child? Is it with her or somebody else?
with her. Both of us took care
What's your grandmother's address?
on 190 Toledo Street.
Okay, what I'm going to do in cause number 23 DCCR 2323, grant the motion to set a bond, and at this time. Well, let me look back at something. So were there any issues? Any positive drug screens?
Yes, when he got arrested in office, he tested positive for THC.
Right, I'm going to deny both of the motions at this time, to set bonds. I don't think it is, proper on probation for 2 felonies. We've got a new allegation of a serious, offense. Got positive drug screens, failing to follow through with the therapy. I think they're probably, if there's going to be a continuation of probation, needs to be something a little more intensive, if we even consider that. All right, you can go back with the bailiff. Mr. Roadhouse will be out there to visit with you, tell you what your options are. Ms. Holmes, you've got Anthony James.
Yes, I believe a dismissal was submitted.
I've signed that dismissal, so we're finished with Mr. James. Robert Joseph, Ms. Holmes.
Your Honor, he has a new case. The prosecutor said they'll probably get an answer whether they'll be indicted within the next week or two.
Okay,
Sorry.
That's okay.
Directed to Charlie.
Robert Joseph.
So we're,
He has agreed to plead to the new offense, Judge. I've agreed to waive the priors that we will wait indefinitely on so that he can go to ISF. If I only have until maybe Tuesday, the 8th, to get it indicted next week, we can do all of this paperwork, and then if the court agrees, send him to ISF.
Okay, so reset 2 weeks.
Yes, ma'am.
Okay. Joseph is reset for 2 weeks.
Yes.
Dejon Banks.
That me?
Can we hold it for a minute?
Yes, ma'am.
Oh, it's not you, it's Mr. Lewis.
Oh, okay.
It was a test, Ms. Holmes. You're like, okay, let me figure it out. I appreciate that. The whole Dejon Banks, I'm sorry that I called your guy, you're on with, anyway, wrong person.
Go for it.
Carry on, Mr. Lewis. I see things showing up on the screen over here. It looks like you're busy back there. Have we seen Mr. Will we be going on count one on these?
I think counting on is just maybe.
At least on,
Burglary is the second. Yeah, burglary is the second. Yes, the fraudulent use is the first degree as alleged, so we're okay.
And we're going on two.
We're going on the two higher level offenses, Judge, and have done dismissals on several
And-
state jail levels.
Okay, and so in that second one, it's also count one only.
Yes.
Right, ma'am, are you Thelma Gilbert?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
She does, too.
Ms. Gilbert, in cause number 26, DCCR 0503, the state is elected to proceed on count one only. It alleges that you committed the second-degree felony offense of burglary of a habitation from February 13th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
Then. Just a second to get to the next one. And cause number 26, DCCR 0507, the state has also elected to proceed on count one only. It alleges that you committed the first-degree felony offense of fraudulent use or possession of identifying information in 50 items or more. And that's from January 22nd of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've reached with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreements that you've reached in each of these cases are for a cap of 15 years in the institutional division of the Texas Department of Corrections, which means you're leaving your punishment up to me. And if I follow these agreements, I can give you anything between probation up to 15 years.
Yes, ma'am.
As long as I don't give you more than 15 years, you cannot appeal. You understand?
Yes, ma'am.
You have an absolute right to have a jury come in and decide two things. The first is to decide if you're guilty or not. And if that jury found you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do?
Yes, ma'am.
State tenders number 1 in each case.
Objection, Judge.
It's admitted in each case. Also, it's my understanding that as part of this plea agreement, the state is going to agree to dismiss cause numbers 26 DCCR 0502, 0504, 0505, 0506, and 0508. Is that your understanding?
Yes, ma'am.
All right. And no evidence that Ms. Gilbert's not competent.
No, Judge.
Right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later date for sentencing. Do you want me to go ahead and sign the dismissal?
That's
or
fine.
wait?
That's fine, Your Honor.
Okay. All right, then we'll see you back at sentencing. You can go back with the bailiff.
Yes, ma'am.
If for some reason you didn't accept the agreement, you're a judge, I'd still focus on these cases.
Okay,
We'll
perfect.
be okay with that.
Okay, thank you, Mr. Nichols.
Okay.
Judge, we'll approach on,
Yeah,
on banks.
give me one second. I don't think we need one very much for that.
And I gotta move on before you to the system.
Who, on who? Okay. Find it. Okay,
Judge, on this one, the state had been,
this one that says final reset.
right,
Last final
Uh-huh.
explanation point.
Uh-huh.
Judge, I was gonna ask if we can set it for 2 weeks for bond hearing. I also got new locate information for the child, where the child is at. I provided for to Ms. Morfino as well. Try to at least make that attempt before we definitely put it on the trial docket. They made an offer with deferred, but considering my client's position that that's something still it wouldn't be willing to do.
And I had a long conversation with family law yesterday about their procedures in this, and I'm willing to put it on the trial docket. Judge, Mr. Lewis just mentioned the bond issue with his being so adamant of not even wanting to take a deferred or take any kind of responsibility, whatever you prefer to do, that he.
Well, I think what I'm going to, well, not I think, what I'm gonna wanna know when I'm considering any kind of bond, obviously you need to get something filed.
Right.
Quickly, and we'll get that set in a couple of weeks, but I'm going to wanna know on that day, the announcement. It's either if there's a deferred offer, she accepts that, or we set it for trial that day. So that needs to take place also that day. So it'll be an announcement and a bond
And the
hearing.
bond hearing.
Yeah, cause I think that will factor into my decision on the bond. Yeah.
Okay.
And I don't anticipate my offer changing. I'm certainly not gonna take that off the table, but I
Okay.
will be ready to announce for trial docket.
Okay, perfect. So we'll go ahead and reset to Juan Banks for 2 weeks. If you'll get that filed today, just so we have something in the file for the bond.
Okay.
Bond hearing and announcement. If you'll put on there, just maybe in the notes that they have to announce that day. Thanks.
Gonna advocate for Morgan since, you know, you said it was last for that case.
Mm-hmm.
But I think the one we just played was the first appearance, so like even though.
There you go. Thank you. Let's see, Perry Heard. Mr. Lewis.
Yeah. There's just one that's the last segment, we got the conversation, we're back. And he is confident, we went to the report.
Hold on, I think you're getting them.
Okay.
Marvin made this.
We need another.
How you doing?
Good. Are you Perry Heard Jr.?
I didn't hear you.
Are you Perry Heard Jr.? Okay, and this is cause number 26 DCCR 0052. Mr. Heard is charged with harassment of a public servant. Mr. Lewis.
Judge, since we've gotten the report back on the competency issue, I've gotten an offer from the state. And I gave that to Mr. Heard. And of course, he had been adamant in requesting a time served offer. I talked to Mr. Smith about it. I really want to bring him out so he can understand that denial of his offer is coming from him. It's not me.
So Mr. Heard, Mr. Lewis can do the best he can to negotiate with the district attorney's office. And so it sounds like he's gotten an offer. Mr. Smith, is there any reason to believe that offer would change?
No, Judge. Mr. Hurd is asking for time served. There is no way I would consider time served in this case. I came down from 10 to 6. That is the lowest that I will go in this case.
So the offer is what the offer is. So what your choice is at this point is to either take that offer or to go to trial and let a jury decide two things. One, if you're guilty or not. And then if they find you guilty, you can leave your punishment up to that jury. The third option would be to plead open to the court as well. So you have about 3 options. You can talk about those options to Mr. Lewis. Time served is not on the table. It's 6 years. It's a trial or it's an open plea to me.
All right, see, I don't know what the charge is.
Well, the charge is harassment of a public servant. I'm sure Mr. Lewis has gone over
Yeah.
that with you. Well, here's the thing. The offer is what the offer is.
All right,
If
so-
you talk to, what I'm gonna do is reset your case for what, maybe 2 weeks, Mr. Lewis, you can go visit. Mr. Lewis is gonna come out to the jail and go over all that with you again.
When,
But listen, hold on, don't talk over me, it's real important, okay? So when he comes out to talk to you, it's important that you don't focus on some other deal. He's going to come out to you with the best deal that he can get from the district attorney's office, and you'll just have a decision to make after talking to him, and we'll get what that decision is in 2 weeks, okay?
all right.
All right, he'll bring the discovery,
Like,
he'll
if,
go over what,
6 years is on there, it'll be out here.
say it again,
So if the 6 years is out here, it will be out here.
out here where, I don't understand your question.
You guys sentenced the 6 years on.
If you get 6 years, then what?
It'll be in Beaumont.
I have no idea. So what happens if you go to TDC, typically is everyone that goes to TDC goes first to Huntsville, and that's where you get classified as to where you should go.
All right, I'm gonna talk.
Hang on, let me tell you, there's more about that though, because typically they try to get you back in the area where you are so that you can have visits and stuff like that. But I don't have any say so over that. That would be, look at me, pay attention. So I don't have any say so over that. That would be up to the prison authorities, okay? All right, go back with the bail.
All right, good night.
Good luck. And good night. Marissa Hearn,
Yes.
Marissa Hearn.
Telling y'all, you're in the wrong line of work.
Oh,
That
for sure.
job
Spit on.
Was all women. In and out of there in an hour and 15 minutes. Fast.
Yeah,
Yeah.
fastest minute for sure. No doubt.
And it keeps going for years and years and years. Perpetuity, yes.
Yes.
Both the girls have births. Why did they were all women?
I know. Yeah. Good morning. Are you Marissa Hearn?
Yes.
And will your client waive the formal reading of the indictment?
He does.
Ms. Hearn, in cause number 26 DCCR 0920, you're charged with the second-degree felony offense of assault on a peace officer, and that's from April 1st of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Mhm.
And it looks like the agreement that you've reached is for a 3-year deferred adjudicated probation. There would not be a fine, but there would be restitution payable in the amount of $1,200. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Hearn is not competent?
No.
All right, sir. Ma'am, I'm sorry. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to bond reduction based on that plea?
I have no objection, Your Honor. She does have some misdemeanor criminal history, and I might suggest to the court to consider a drug patch. I think that was the issue on her underlying misdemeanors as well as probably this.
Perfect. So, Ms. Hearn, what I'm going to do, based on the nature of your plea agreement, is going to reduce your bond in your case to $1,000. If you make that bond, there will be a requirement that you have a drug patch. You will be required to get that drug patch within 24 hours of your release from custody. It's something you have to get changed every 2 weeks. Your bondman can let you know where you can get that done. Obviously, if you make that bond, you get the drug patch and there's a positive test on it before we come back for sentencing, you run the risk of me not accepting this plea agreement and things could be much worse. Do you understand? Also, if you make the bond and you're arrested for anything else between now and we come back for sentencing, you're also run the risk of me not accepting the agreement. Do you understand? Okay, we'll see you back at sentencing. Kadisha Scott. Good morning, ma'am. Are you Kadisha Scott? And Mr. Lewis, will your client waive the formal reading of the indictment?
She does.
Ms. Scott, in cause number 26, DCCR 0797, you're charged with a first-degree felony offense of aggravated robbery from July 3rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like that agreement is for a 10-year deferred adjudicated probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Scott is not competent?
No, Judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Based on the nature of the underlying offense, at this time, I'm not going to look at that bond. I think I want to get the pre-sentence report. Okay, you can go back with the bailiff. You've got Larry Fitzgerald Williams Jr.
William.
Sorry. Snuck up on quiet like a ninja. You saw me call you like 3 times in a row because I was in defense tactics trying to go. I was thinking after Dickie. Good morning. Are you Larry Fitzgerald Williams Jr.?
Yes,
And Mr. Williams has calls number 23 DCCR 1363 on probation for evading arrest or detention with the use of a vehicle. Motion to revoke unadjudicated probation has been filed in that case. It has 2 new indictments. Cause number 26 DCCR 1470 charged with abandoning or endangering a child. And then clause number 26 DCCR 1471 charged with continuous violence against the family. And what is the announcement?
Judge, at the top of Mr. Williams, I do need a little time to look at those new indictments. Those were just things just indicted like last month.
They were.
But I need to look into not only some information with family that was involved, but also for his mental health and treatment he had been receiving, like he had been offered the meds during that time. So
Right, we'll just do a normal reset. Is that fine?
Yes, Judge, if I may, just so that it's clear to Mr. Williams. I know
Yes.
Mr. Lewis and I have spoken about this. I handled, as did the court, the underlying case for which he is on probation, so I'm quite familiar with this defendant. It is my position, after speaking with Ms. Lopez as well, that if we proceed to a hearing on these, I think we could handle them in a hearing because it's a 3rd-degree probation, a new 3rd and a new state jail. So I'd be ready to proceed in the hearing, but I will ask the court at that time, based on your findings, to consider the possibility of running those consecutive. In the alternative, I had made a plea to run things concurrent, and be entered pleas of true and pleas of guilty. So when we get to that point, I just wanted the court to know my position would be to have a brief hearing. I think we do it in an hour or so, maybe a little more, and I will be, if need be, I'll file a written motion, but it will be my position to ask that they bring it second.
Okay. So what I'll do then, Mr. Williams, is reset your case. You can visit with Mr. Lewis once he gets all the information about those two new cases, what the offer is, what your options are, and we'll see where we are at that next court date.
Thank you.
All right, you can go back with the bailiff. Thank you, Ms. Lopez. So is that it for you, Mr. Lewis?
I think so.
Mr. Rojas, Sarah Jordan.
Yeah.
We are going, it looks like on some of the priors.
Yeah, they're both gonna be 30 minutes.
Good morning. Are you Sarah Jordan? Mr. Rojas, will your client waive the formal reading of the indictment in each case?
She will, Your Honor.
Ms. Jordan, in cause number 25 DCCR 1401, you're charged with a state jail felony offense of unauthorized use of a vehicle from February 21st of 2025. That indictment also alleges that you were previously convicted of the state jail felony offense of possession of a controlled substance, July 26th of 2013. And after that, you were convicted of the state jail felony offense of possession of a controlled substance, November 16th of 2017. And then after that, convicted of state jail felony offense of theft, January 26th of 2022. And on that same day, also a state jail felony of possession of a controlled substance. And then after all of those were final, you were convicted of possession of a controlled substance, a state jail felony, January 5th of 2024. How do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty in that case freely and voluntarily?
Yes, ma'am.
And also your pleas of true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes.
with?
And Judge, at the appropriate time, I know the court will need an explanation as to why I made the offer.
Okay, good. Just a second. All right, then. We have clause number 25. DCCR 1403. And in that case, you are charged with a state jail felony offense of theft of
Yes.
property with previous convictions from June 4th of 2025. It alleges in this indictment that you were previously convicted of theft August 7th of 2007, and then again, January 26th of 2022. It also alleges those same prior state jail felony offenses as well. And how do you plead to that charge?
Guilty.
And are those prior convictions all true?
Yes, ma'am.
And again, in this case, did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually have done what they've charged you with?
Yes, ma'am.
In both of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Explanation?
I know that the history does not dictate such an offer. I think there are some extenuating circumstances that I took into consideration. One being the underlying offense themselves. I think her co-defendant, Brandon Lewing, who's also sat before the court, is actually the more culpable party, especially in the UUMV. His case was supposed to be resolved last week, and Mr. Smith ended up withdrawing from that case, so it is still pending. Ms. Jordan has agreed to cooperate against Mr. Lewing if necessary. He actually has about twice as many priors as she does. It's also my understanding that when she discharges from TDC, and correct me if I'm wrong, that she's been accepted into a women's center type program, invite her to try to help get her back on the right track and keep in touch with me so that if we need to use her cooperation, we can. That was my thought process when making this offer. I certainly understand if the court doesn't think it's appropriate.
No, I appreciate the explanation. Ms. Jordan, each of those cases I have here on the tablet, these documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also want to make sure you understand if I go along with these agreements and you're back here on any other felony, I'm going to take it pretty personally, and probably Ms. Malfino will too. You're not going to get deals like this again. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation,
Yes, ma'am.
exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Ms. Jordan is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. In cause number 25, DCCR 1401, find sufficient evidence to find you guilty. At this time, find you guilty of unauthorized use of a vehicle. Find those prior felony convictions true. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Thank you.
Cause number 25, DCCR 1403, also find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas, excuse me. All right, thank you, ma'am. You go back with the bailiff.
Thank you. Thank you so much.
Thank you.
This courtroom hearing centers on Alexis Baja Cooper, who has already pleaded guilty to stealing more than $3,500 worth of cosmetics and makeup from an H-E-B store. But as the court begins to hear the details, it becomes clear that this was not being treated as a simple, isolated theft. A loss prevention officer explains that Cooper had been linked to multiple theft events across Montgomery County and had allegedly been working alongside other individuals connected to a larger organized retail theft operation. According to the testimony, Cooper was connected to 10 separate theft incidents between February and April of 2024, with losses totaling nearly $9,000. And when the court hears about the overall operation, the numbers become even more serious. The loss prevention officer describes the group as one of the most significant organized retail theft operations she had encountered during her 5 years of experience. The investigation connected Cooper's alleged co-defendants to tens of thousands of dollars in additional losses. While Cooper's case focused on her own charges, the testimony painted a much larger picture of a group allegedly traveling from county to county and repeatedly targeting stores. Then comes an unexpected moment. Even